Very good evening, all the participants. In this fourth session on Companies Act 2016 of Malaysia, we will be covering the corporate rescue rules, practicing certificate of company secretaries, auditor and liquidator fees, and accessing register of beneficial ownership. So with this fourth session, we will be having a complete overview of the Companies Act 2016 along with regulations and rules. So let me start with this corporate rescue rules. So there are provisions, as you know, in the Companies Act regarding rescuing companies. So we have already discussed the provisions in the Act, and now let us have a look at the rules also. So overview of the rescue rules framework. Part 1 deals with the preliminary, which is citation and commencement, 1st of March 2018, and application of Rules of Code 2012 to unspecified matters. Part 2 deals with voluntary arrangement, which contains proposals, reporting of meeting results, moratorium, management and withdrawal or replacement of nominees. Part 3 deals with judicial management, which contains orders, court applications, creditor meetings, proof of debt, wages claims, and committee formation. Part 4 is general, which include court fees, open court versus chambers hearing, notice requirements, and regulatory compliance provisions. There are 23 prescribed forms. There are standardized forms for all voluntary arrangements 1 to 8, judicial management 9 to 18, and general 19 to 23, which covers the general procedures. Effective date is 1st of March 2018, when these rules came into operation and became applicable to all corporate rescue proceedings. Part 1 Preliminary Provisions. So formally cited as the company's corporate rescue rules 2018 in all official proceedings and documentations. The rules came into operation on 1st March 2018, applying to all proceedings commenced on or after that date. Regarding application of Rules of Code 2012, so Rules of Code 2012 apply to all procedures and matters which are not specifically provided for in these rules, ensuring procedural completeness. Part 2, Voluntary Arrangement Procedures. So step 1, filing proposals. So companies file restructuring proposals with court, nominee is appointed, proposal must be viable and fair to creditors. Step 2 is the moratorium period. Protection period commences and moratorium on creditor enforcement actions and company continues operations. Step 3 covers creditors meeting and voting. So creditors vote on the proposed arrangement. Requisite majority is needed for approval. Step 4 is reporting meeting results. So nominee or administrator reports outcomes of creditors and members meetings to court and all stakeholders. Step 5 is the end of the moratorium, where protection period concludes and arrangement is either implemented in case approved or company proceeds to other remedies. Voluntary arrangement. Let us understand the key features and benefits. First of all, let us have a look at the core procedures. So first of all, there is a filing of a proposal for restructuring. Creditors meetings and voting take place. There is reporting of results and moratorium period management. Nominees can be withdrawn or replaced as needed during the process, and court approval is required for withdrawal and replacement. There is a high degree of flexibility in negotiating terms directly with creditors, and company retains management control. What are the advantages? Moratorium shields company from enforcement actions during restructuring negotiations. Company continues trading throughout the arrangement process, so there is continued business operations. Creditors actively participate in votings and high majority is required and binding on all once such restructuring proposal is approved. So costs are lower as compared to judicial management and less court involvement, and faster resolution is possible through this voluntary arrangement process. Part 3 is judicial management. So companies or creditors, they file applications with court supporting documentation required and court sets hearing dates. Applications must be properly served on all relevant parties and advertised according to court rules. Creditors must file formal proof of debt claims with supporting documents and court examines and admits valid claims. Employees have priority wage claims up to specified limits and special protections are there for employee entitlements. Creditor meetings, formal meetings with prescribed quorum, voting procedures and minutes recording requirements are there for meetings of creditors. Committee of creditors established to oversee and advise on various matters. It monitors judicial managers' actions and approves major decisions which are taken during this process of judicial management. Creditors meeting and voting procedure. Notice and summoning. Formal notice is sent to all the creditors with meeting details, including time, venue, and agenda to be discussed. There are certain quorum requirements. So minimum creditor participation levels must be met before the meeting can validly proceed. Step 3 is the voting process. Creditors vote on proposals and decisions. Votes weighed by value of admitted debt. Step 4 is minutes and records. Detailed minutes are recorded and maintained and copies provided to court and all participants. Step 5 is cost allocation. Meeting costs is distributed according to prescribed rules and it is treated as expenses of the judicial management. Judicial manager. What are the responsibilities and duties? The core responsibilities of the judicial manager include managing company affairs during the judicial management period under supervision of the court, preparing statement of accounts, supervising all creditors meeting, liaising with committee of creditors, handling proof of debt submissions, implementing court orders, facilitating the restructuring plan. What are the duties of the court? Managing moratorium period. So court ensures that no creditor enforcement actions are proceeded without the leave of the court. You have to report to the court on progress of the judicial management and you have to seek directions of the court wherever such directions are necessary. Judicial manager is an officer of the court and it owes duties to the creditors collectively, not to any individual creditor. Comparison. Voluntary arrangement versus judicial management. Initiation. Voluntary arrangement is filed by company. Judicial management is applied by company or creditors with approval of the court. Timeline. In case of voluntary arrangement, it is flexible and there is a negotiated timeline. In case of judicial management, this being court supervised, there is a structured timeline. In case of voluntary arrangement, there is a high degree of creditor involvement. So high direct creditor participation is there. Whereas in case of judicial management, court appointed manager oversees the entire process. In case of voluntary arrangement, there is limited court involvement. But in case of judicial management, high court oversight is there throughout the entire process. In case of voluntary arrangement, high flexibility is there in negotiating terms. Whereas in case of judicial management, it being structured is a less flexible approach. Regarding voluntary arrangement, lower costs are there, but in case of judicial management, higher costs are there due to extensive court involvement. Now let us see the rights and protections during corporate rescue. Creditors' rights. Creditors have the right to participate in meetings, vote on proposals, file proof of debt, and they can challenge decisions through court proceedings. Regarding employee rights, priority wage claims up to specified limits, protection of employment entitlements, and right to notice and information. Regarding company rights, there is a moratorium on creditor enforcement actions, continued operations during rescue process, and there is opportunity to restructure. Court oversights the protection all stakeholders, judicial manager accountable to court, and appeal mechanism is available. Now forms and documentation requirements. Forms 1 to 3 for voluntary arrangement, which include proposals for voluntary arrangements, nominees report, and supervisors report of arrangement. Form 4 to 6, five-way notices, notices related to voluntary arrangements, notice of moratorium, and notice of termination. Form 7 to 8, voluntary arrangement reports. These are reports on voluntary arrangement progress and creditors meeting results. Form 9 to 12, regarding judicial management. These include application for judicial management, affidavits supporting applications, Form 13 to 15 of judicial management affidavits. These contain affidavits supporting judicial management applications and proceedings, and Form 16 to 23, which relate to proofs and general formats. So these are proofs of debt documentation, general notices, communications, certificates, and correspondence. Part 4. General provisions in case of court procedures. Let us see the procedure regarding court fees and rehearing rules. So there is a specified fees for various filings and actions related to voluntary arrangements and judicial management proceedings. Open court versus chambers, contested applications, appeals, and important legal questions heard in open court, and administrative and non-contentious matters in chambers. There are requirements for serving notice on all relevant parties, and timing and mode of service of notice are also prescribed. Regarding procedure categories, Rules of Code 2012, they apply to all procedures and matters which are not specifically addressed in these rules. Contested applications are heard in open court besides appeals and important legal questions. But non-contentious matters, administrative procedures, preliminary hearings, and routine applications, they are heard in chambers. All participants must adhere to the prescribed rules and court orders throughout the process. Now let us see the key takeaways of these companies' corporate rescue rules 2018. Effective on 1st March 2018, and applies rules of code 2012 to all matters which are not specifically covered by these rules. So there are two core mechanisms. One is voluntary arrangement, which is company led and is more flexible, and judicial management, which is court supervised and is structured. Voluntary arrangement offers moratorium protection, continued operations, and lower costs, and it requires creditors' majority approval. Judicial management is done through a court officer who is responsible for managing company affairs, meetings, and restructuring implementation. 23 prescribed forms are there which cover all voluntary arrangement, judicial management, and general procedures, and all stakeholders, whether it be creditors, employees, company, they have specific rights and protection throughout the rescue process. Now, let us have a look at the practicing certificate of these secretaries. Let me share the presentation. So companies practicing certificate for secretaries regulations 2019. Regulatory authority made under paragraph 6131A of the Companies Act 2016, Act of 777 by the Minister of Domestic Trade and Consumer Affairs. Effective date is 15th of January 2020 when it came into operation, and it is applicable to all company secretaries seeking approval or renewal. Previous regulations regarding the fees, company auditors, and liquidator regulations 1966, these have been revoked, and these regulations, these new regulations, these modernize the fees framework. Publication reference, these were published in Gazette through official publication reference for all regulatory compliance purpose. Let us see the purpose and scope of the regulations. So it establishes a standardized fee structure for the approval and renewal of company auditors and liquidators in Malaysia under the Companies Act 2016. Auditor approvals, it governs the approval and renewal of company auditors, ensuring professional standards and regulatory compliance in audit services. All services carry a uniform fees of 500 ringgits, ensuring consistency and clarity in regulatory costs. Regarding liquidator approvals, it establishes procedures and fees for approval and renewal of liquidators in company dissolution and liquidation processes. There is transparent pricing. It provides transparent and uniform fee schedule for all regulatory approvals and renewal of credentials. It ensures that only qualified and compliant professionals are approved, maintaining integrity and professional standards. Regarding the approval and renewal process. So first step is the submission of application by the applicant. So applicant submits approval application with required documents, qualifications and evidence of professional standing. Step 2 is the application review. Regulatory authorities review compliance with Companies Act 2016 requirements and they verify professional credentials. Step 3 is approval or renewal decision. Decision on approval or renewal of credentials is made and applicant is notified of outcome in writing. Step 4 is fees payment. Approved applicants pay the prescribed fees of 500 ringgits and payment is required before credentials are issued. Regarding schedule of fees, company auditors and liquidators. Company auditor approval. Initial approval as company auditor, 500 ringgits per approval application. Company auditor renewal, annual renewal of company auditor approval, 500 ringgits per renewal application. Liquidator approval, initial approval as liquidator, 500 ringgits per approval application. And liquidator renewal, annual renewal of liquidator approval, ringgits Malaysia, 500 per renewal application. Fee structure analysis. Standardized fees approach. So all services, auditor approval, auditor renewal, liquidator approval, liquidator renewal carry a uniform fees of 500 ringgits. Fees uniformity. 100% consistency in pricing structure across all 4 categories and service types. And fees paid are permanent and non-refundable. Once submitted, applicants must ensure eligibility before applying. What are the benefits and exceptions? So uniform fee structure, it provides predictable regulatory costs for professionals, facilitates budget planning. It removes complexity in fees determination. Professionals know exactly what to expect. Each approved professional must renew credentials annually, ensuring consistent regulatory oversight. And registrar may reduce or waive fees partially or wholly based on the assessment of circumstances. Just a minute. Categories of regulated professionals. So category A includes company auditors who are professionals conducting statutory audits of company accounts and they must be registered with Malaysian Institute of Accountants. Category B includes liquidators who are professionals managing company dissolution and insolvency proceedings must be approved by Minister of Finance. Fees obligation, initial approval, 500 ringgits payable upon first application for approval in either category and these are to be paid before credentials are issued. Annual renewal fees obligation is also there, which is 500 ringgits payable each year upon renewal and failure to renew results in lapse of approved status. So key provisions and compliance requirements. All applicants seeking approval or renewal must comply with requirements outlined in the Companies Act 2016 and provide necessary documentation. Professionals must renew their approval status annually or as per the frequency specified by the regulatory authority to maintain credentials and legal status. Regulations ensure only qualified and compliant professionals are approved, and it maintains integrity of audit and liquidation services. Applicants must submit prescribed documents, including evidence of qualifications, professional membership, and relevant experience. Approved status may be revoked or renewed or refused for criminal convictions could be there for in case of breach of professional standards or failure to comply with the provisions of the act, which may entail in disqualification and criminal conviction, besides revocation or renewal of approved status. Legal authority and chain of regulations. Let us see the legislative hierarchy. So primary legislation governing all this is Companies Act 2016, which is Act 777, which is the foundation law governing all company related regulatory matters in Malaysia. Delegated authority as per paragraph 613 1A grants the minister specific power to make regulations prescribing fees for approvals and renewals. Subordinate legislation, companies auditor and liquidation fees regulations 2020, which is directly enforceable on all regulated professionals. Implementation is done through supersession and revocation of the earlier fees, company auditors and liquidators regulations 1966. Effective date of these regulations is 15th January 2020, and all approvals and renewals from this date subject to 500 ringgit fee schedule. Enforcement is done by Registrar of Companies, which administers the regulations, and non-compliance may result in refusal of application. Now let us see the key takeaways for this practicing certificate regulations made under paragraph 613 1A of Companies Act 2016, effective from 15th January 2020, and these revoke the earlier regulations. Covers two categories, company auditors and liquidators. Both are subject to identical fees obligations of 500 ringgits. Uniform fee of 500 ringgits applies to all four transaction types: auditor approval, auditor renewal, liquidator approval, liquidator renewal. Fees are non-refundable. Registrar has discretion to waive or reduce fees in appropriate circumstances. Annual renewal is mandatory to maintain approved status, and lapse of approval affects ability to practice. Framework ensures professional standards in audit and liquidation services are maintained under Companies Act 2016, which is established under Act 777. Now, let us see the provisions regarding this auditor and liquidator fees. These are contained in Company Auditor and Liquidation Fees Regulations 2020. And these are also effective from 15th January 2020. So regulatory framework and background. Legal foundation is the Companies Act 2016, which is the primary legislation establishing the regulatory authority for all company related matters, including professional fees. Paragraph 613 1A defines the this delegated authority, which specifically empowers provision granting the minister authority to prescribe fees for professional approvals. So previous regulations on this, the fees, company auditors and liquidators regulations 1966, it was revoked and superseded by this modern framework. And effective date is 15th of January 2020. And it is applicable to all approvals and renewals from this date. Now let us understand the scope and key information. So official gazette reference for this subsidiary legislation is PUA 9 oblique 2020. Regulations title is Companies, Company Auditors and Liquidator Fees Regulations 2020, which is the full official title. Effective date is 15th of January 2020. This is the date when regulations came into operation and became binding. Earlier, these regulations, the prior fees, company auditors and liquidator regulations 1966 is hereby repealed. Schedule of fees. 500 ringgits in all the cases. Company auditor approval, company auditor renewal, liquidator approval, and liquidator renewal. Company auditor and liquidator services. So approval process 500 ringgits, renewal process 500 ringgits. Scope, regulatory oversight, compliance verification, ensuring professional standards in statutory audit services. Eligibility, it must be registered, the professional must be registered with Malaysian Institute of Accountants and meet all professional requirements under Act 777. Liquidator services. Approval process 500 ringgits, renewal process 500 ringgits. Scope, liquidation management, company dissolution support, administration of insolvent company states. Eligibility must be approved by the Minister of Finance, meet qualification requirements as prescribed by the registrar. And there is a unified fee structure. It ensures regulatory clarity and consistency across both professional categories. Fee structure all across is 500 ringgits. Service categories are 4: company auditor approval, company auditor renewal, liquidator approval, liquidator renewal, right? And fees uniformity is 100%. So complete consistency in pricing structure, no variation based on company size, volume, or other factors. Implementation path. Regulatory basis. So these were made under Companies Act 2016, paragraph 6131A, and were made legally enforceable on all regulated professionals. Came into operation on 15th January 2020, and all approvals and renewals from this date subject to 500 ringgits schedule. Unified fee structure, 500 ringgits for all 4 categories: auditor approval, auditor renewal, liquidator approval, liquidator renewal. And previous regulations of 1966 were superseded, and all prior fees obligations are replaced by this modern simplified structure. Companies Act 2016, Act 777 is the primary legislation which establishes the entire framework for corporate regulation in Malaysia. Paragraph 6131A grants minister specific power to prescribe fees for professional approvals and renewals, and these regulations 2020 are directly enforceable and binding on all regulated professionals. Regarding administration and enforcement, the registrar is the person who administers the fees collection, reviews applications, issues or renews approvals upon fees payment. Failure to pay prescribed fees results in refusal of application and lapse of approval status. Registrar may exercise discretion to waive or reduce fees in prescribed circumstances upon application. Applicable categories. So across all categories, the fees is same. So unified framework ensures consistency and clarity, and it removes complexity from prior 1966 regulations. Now, let us see accessing this register of beneficial ownership. Let us see this chapter 7, which deals with beneficial ownership 2025. Regulatory framework established under Companies Act 2016, subsection 60B, subsection 9, and paragraph 6131 double A, which is the dual legal foundation. Effective date is 10th of January 2025 and full enforcement of all provisions from this date and most recent addition to Act 777 framework. The scope is it governs access to company registers of beneficial owners and controls who may request and receive this information. Purpose is combating money laundering, terrorism financing, and proceeds of unlawful activities through transparency. Beneficial owner may access their own information directly at the company's registered office. No formal application is required. In case of authorized representative, access is granted with written approval from the beneficial owner and it must produce written authorization. Regarding Bank Negara Malaysia, access as competent authority under AMLA, it acts as Financial Intelligence Unit for financial crimes. Enforcement agencies, all Malaysian enforcement agencies which are defined under AMLA 2001, Section 3, Subsection 1 have access to registers. Proof required is the identification card, passport, authority card or written approval. Appropriate proof must be produced. Now, access to beneficial ownership information lodged with the registrar. First was the access to company's register of beneficial ownership, where access was granted to various persons as per the provisions. Now, let us see the provisions regarding access to beneficial ownership information which is lodged with the registrar. Beneficial owners, they can access their own information lodged with the registrar, but proof of identity is required. In case of authorized representatives, they can access the records with written approval from beneficial owner and formal application to registrar has to be filed. Regarding reporting institutions, under AMLA, institutions listed in first schedule of AMLA include banks, insurance companies, money service businesses. Bank Negara Malaysia as competent authority and financial intelligence unit, broad access for AML and CFT purposes. Enforcement agencies. All Malaysian enforcement agencies, including police, customs, and specialist financial crime units. Government entities, which include federal, state, and local government entities, specifically for government procurement purposes only. Now, application requirements for formal access. Prescribed form must be completed and submitted to the registrar for all formal access requests. A fees of 20 ringgits is payable to the registrar and it is non-refundable upon submission of application. Proof of entitlement authority to access the information must accompany the application in the form of a written letter. Registrar has discretionary power to require further proof or impose conditions or reject applications. Registrar may supply information in forms determined by the registrar and it may impose conditions on any access grant. Registrar may also reject applications which are deemed as non-compliant by specifying reasons for rejection. They are to be provided in writing. Now, discrepancy reporting process and timelines. So, person or entity receives beneficial ownership information from the registrar upon approved access. Recipient compares the registrar supplied information with information obtained or known to them independently. Step 3 is discrepancy found. If a discrepancy is identified between the two sets of information, the recipient has an obligation to act. Step 4 is report to registrar. Discrepancy must be reported to the registrar and timeline is it has to be reported within 30 days from the date of information supply. Step 5 is registrar directs the company. So registrar directs the company to review, amend, rectify or vary the information as required. Fee structure 20 ringgits for access. It is non-refundable. So registrar discretion to either reduce or waive the fees partially or wholly, based on assessment of individual circumstances, and prepayment is required before application is processed. No fees, no processing of application. Key definitions: enforcement agency as defined under Anti-Money Laundering, Anti-Terrorism Financing and Proceeds of Unlawful Activities Act 2001, Section 3, Subsection 1, which includes police, customs, intelligence agencies, specialist financial crime units, financial intelligence units under Bank Negara, Malaysia. In case of government requirement, which is defined as procurement for goods, services, or works financed by federal government, state government, or relevant local authority, specifically for government operations or public interest. Reporting institutions. Institutions listed in first schedule of AMLA 2001 includes licensed banks, insurance companies, money service businesses, and capital market intermediaries. Beneficial owner is the person who ultimately owns or controls 20% or more of shares or voting rights in a company, either directly or indirectly. Examples of government procurement include tender process for national infrastructure projects financed by federal funds. Registrar powers and enforcement authority. Information discretion. So registrar may supply beneficial ownership information in forms determined by the registrar and formats may vary by request type. Application review may require additional proof, documents or information before approving any access application. Registrar may grant conditional approval also by imposing conditions on any access grant, and recipient must comply with conditions or access may be revoked. Registrar may also reject applications which are deemed as non-compliant, and discretion is broad and subject only to judicial review. Regarding enforcement direction, it may direct companies to review, amend, rectify, or vary beneficial ownership information upon receipt of discrepancy report. A registrar may also order corrective action or other remedial actions as needed to ensure accuracy and completeness of beneficial ownership records. Access requests framework. Branch 1. Direct access. Company register. Beneficial owner or authorized representative can access company's own register directly at registered office by producing proof of identity or authorization. Branch 2. Formal application to registrar. So all other eligible entities, they must submit the prescribed form plus 20 ringgit fee plus written letter plus additional documents to registrar. Registrar has the power to review. Registrar shall review the application and it may request further information and then make a decision regarding approval or non-approval. So in case it is approved, access is granted and information provided in registrar's prescribed format. If it is approved with conditions, access granted subject to specified conditions and which recipients must comply. And in case application lodged with the registrar is rejected and application refused, reasons have to be provided, but there shall not be any refund of 20 ringgits of fees, but appeal to court is possible. So now let us see the key takeaways regarding access to register and beneficial ownership 2025, which were made effective with effect from 10th of January 2025. And these are established under subsection 60B, subsection 9 and paragraph 6131 AA of Companies Act 2016. Whereby beneficial owners and authorized representatives may access company register directly, but all others must apply to the registrar. Eligible participants include beneficial owners, AMLA reporting institutions, Bank Negara Malaysia, enforcement agencies, and government entities, procurement only. Formal application requires application in prescribed form plus a fees of 20 ringgits plus written letter plus additional documents as required by registrar. If there is a discrepancy in beneficial ownership information, it must be reported to the registrar within 30 days, and failure to do so is an offense. And registrar has extensive discretion to approve, impose conditions, reject applications, and direct company corrective action. So this was all in brief about the Companies Act 2016, including regulations. So I've tried to give you a brief overview of the Companies Act 2016 as applicable to Malaysia, along with regulations and rules. These videos are basically meant for students of company law who may be doing graduation, they may be law graduates or they may be professionals trying to have an overview of the Companies Act 2016. If you like these videos, you can subscribe to our channel so that you keep receiving updates about our future endeavors, which shall include insolvency laws in Malaysia. If you want a copy of the slides being used in these video lectures, you can write an email to me. I'll share my email ID in the comment section. Thanks for watching. Thank you so much.